Good morning, everyone. My name is Bernard Tolliver, for those of you who don't know me. On behalf of Chris Beer and Peter Chapman, many of you met outside, I want to welcome you to the 6th Annual Class Action Money and Ethics Conference. I don't know what it was like to the rest of you this morning, but when I woke up, I heard this loud sound. I thought something strange was going on, then I realized it was actually pouring rain outside, thundering. So we're very honored that all of you are here. We expect to have a few more people throughout the day, and I want to give our first panel all of the time that they have on the schedule, and so I'm going to turn it over to Mr. Baldo, Betty, and his team from Proscour. Again, thank you all for being here. Enjoy your day, and if there's anything that you need, just check with us. Thanks, everyone. Good morning.
Great, thank you, Bernard. As Bernard said, my name is Baldo Vinti. I'm a partner at Proscour Rose. I'm in the IP group, I head the IP group, and with me are my colleagues Jennifer Yang and Jeff Rashofsky. We are advertising lawyers. We represent clients on the defense side, and at any given time, we have about a dozen or two class actions that we're handling, in addition to a number of class actions that are threatened that are not public. And so we're well versed in this area. And so we thought it would be good to talk a little bit about trends that we're seeing in the advertising space and the class action space particularly. And the reason being, it's important because when you're representing clients in this space, the class actions are a significant matter for a lot of clients. The exposure they bring, the time and effort it takes to defend one of these matters is tremendous. And so it's good to have a strategy and anticipate where the next class action may be. And so what we do is we tend to track all the advertising cases that are publicly filed. We track all the settlements that are filed, and that allows us to basically advise clients not just when the lawsuit happens, but in advance of the lawsuit. And so why does it matter? Here's an example of some recent settlements. And as you can see, they are pretty extensive, right? They're in the Reckitt case was a $15 million settlement. It had to do with supplements. And then we've seen a lot of activity in the food and beverage space. And you saw there are two class action settlements related to cereals. Like I said, we track all the class actions that settled, at least publicly settled. And in 2021, our estimate was that the average settlement was about $5 million. And that includes payment to the class, it includes the attorney fee portion as well. We'll talk a little bit about settlement later. There's obviously the class settlement, and there's benefits to that. There's also individual settlements, which are typically less than the $5 million average, much less than that, probably more in the five-figure range. But those are something that are also out there. Unfortunately, that's not public, so we don't have stats on that. But what are the strategies for avoiding large class action settlements? And again, it all starts with the claims, right? Vetting the claims. So when your client comes to you and they have new advertising, what we typically do is we look at the claims, not just for the literal message, but also for the implied message. And that's where a lot of times folks get into trouble, is the implied message. And that's not to say that you can't make advertising that has an implied message. In fact, that's often a benefit of the advertising. But what you want to do is make sure that the implied message is substantiated. And if it's unclear or there's more than one interpretation, then what you would do is having some sort of disclaimer or qualifier. Another tip we always say is don't be the low-hanging fruit, meaning that if you're the outlier and your competitors are doing something different, that doesn't mean you shouldn't have that advertising as long as it's substantiated. But you should be aware, right, that you are going out on a limb. Your competitors may not have this type of aggressive advertising, and so you need to make sure that you're buttoned up and that you have the substantiation, or you have the appropriate disclaimers. And then lastly, which leads into the next segment of this, is watch out for hot areas. So again, your advertising may be substantiated, may be truthful, but if you're in a hot area, you're going to be a target of the various plaintiffs. So what you want to do is get your clients attuned to that, make sure that they understand the risks, make sure that you're in the best position you can be to file a motion to dismiss, to avoid class certification by having strong positions. And really, it's about anticipating what the next move is by the plaintiff's bar and trying to stay ahead of that. And so I know some of you are in the plaintiff's bar, and we have a good relationship with the plaintiff's bar because a lot of times when we settle these cases, you have to work closely with the plaintiff's bar to reach a settlement. But our strategy, at Proskauer, is when we get a case, we look at it as if we're going to try the case. Even though most cases don't go to trial, that's the way we look at it, and I think that's what most defense counsels look at. And so I think it's really anticipating where you're going to be, 2 years down the road. Even if you don't get there, I think it makes for a more robust defense. And with that, let me turn it over to my colleague Jen Yang. She'll talk about some of these. Jeff Wachowski. He's going to talk about these some of the hot trends that we're seeing in the last couple of years.
So Baldo explained why keeping track of the trends is important. In short, it's a way to avoid some of those really big dollar numbers in terms of settlements. And so we're going to walk through now some of the trends. There we go. So one area that's been hugely popular the last couple of years is these flavoring cases, basically alleging that a product, usually a food or beverage, is advertised as having a certain flavor, but then the allegation in the case is that the flavoring isn't derived primarily or exclusively from the advertised ingredient. And so some of you may have seen in 2020, there were hundreds of cases challenging vanilla products brought by one particular lawyer. Basically, those cases allege that products labeled with the word vanilla were deceptive because their vanilla flavoring didn't come exclusively from vanilla beans. Those cases have slowed because courts around the country have typically dismissed them on the pleadings, finding that reasonable consumers would not interpret the word vanilla as meaning the flavor derives mostly or exclusively from the vanilla bean plant. So then we saw some cases involving white chocolate, basically alleging that white baking chips or other chocolate products were falsely advertised as being white chocolate. Similarly, those cases have not fared too well because courts have found that no reasonable consumer would think that something is made with white chocolate just because the package says white on the label. Even though these cases overall have not fared well, some have survived the motion to dismiss stage, and they're still being filed, including targeting new flavors like those on the screen there. Lime, strawberry, fudge, smoked, lemon butter are some of the ones we've seen in the last year or so. So this is definitely something to watch out for if you're selling products with these sorts of flavors or other flavors. If you do get to the vanilla and white chocolate cases, I think give a good roadmap for obtaining an early dismissal. So this is another flavoring case that sort of predated the whole wave. This is actually a case that we litigated a few years ago, and it illustrates how courts typically approach these cases, which I would say is approaching them with common sense and looking at things in context. So here the plaintiff challenged advertising for this truffle flavored olive oil, arguing that the product's name, which just says white truffle, and the picture of a sliced white truffle on the front label reasonably suggested that the product contains actual white truffle. In fact, it does not. It includes, like most truffle flavored olive oils, it's in synthetic fragrance or flavoring. So the district court and the Second Circuit Court of Appeals agreed with our motion to dismiss that reasonable consumers would see that truffles were not listed on the back label on the ingredient list. And they would also appreciate that a $10 bottle of olive oil probably does not contain literally the most expensive food item in the world. So again, this case is a good example of how common sense and context can really make a big difference because courts evaluate these complaints under the reasonable consumer standard. The theory of deception has to be reasonable, not just, I was deceived. So, a lot of you have probably seen Made in USA cases, class actions challenging those, and those have trickled off a little bit, although the FTC has a new rule, and they've been enforcing that, so it's still something to watch out for. But the trend we've seen in the last couple of years has been class actions alleging that companies are falsely advertising their products come from some particular location that's desirable given the type of product. So King's Hawaiian rolls being made in Hawaii, allegedly, or the theory that the Twinings English breakfast tea label suggests it comes from England. In the Hawaiian's roll case, the plaintiffs allege that the words established 1950 Hilo Hawaii conveyed that the products come from Hawaii. And the court disagreed. Just because a company was established in a location at a certain point in time doesn't mean that its products are still made there. And further, the back label said, like many back labels do, where the company was based now and where the product came from. I will say, some of these cases come out differently. It really depends on the context and how definitive the front label is in terms of expressing a message that the product comes from a particular location. So a new trend in the last year or so are these cases challenging the number of servings in a product. And we've mostly seen these lawsuits involving coffee products, although they have extended to other types of products. And basically, what the plaintiffs are alleging in these cases is that the front label or sometimes the back label of a product says that it makes X cups of coffee or up to X cups of coffee, or whatever number of servings if it's a different product. And the plaintiffs allege, I scooped it out, or my counsel scooped it out, and I didn't get that number. And so there's been a huge wave of these cases, relatively simple in terms of the theory of false advertising, but they've been pretty lucrative in terms of the settlement dollars, and so they continue to be filed. And so it's definitely something to watch out for if you're selling any type of powdered product where you're claiming a number of cups or servings or otherwise. And very recently, we saw this branch out into a slightly different type of case involving unit counts. And so here, this case filed against Procter & Gamble alleged that Bounty's advertising stated that 12 singles plus rolls of this towel is equivalent to 18 regular rolls. And the allegation is that's false because P&G has said elsewhere that a regular roll contains 63 sheets per roll, which is more than the number needed for this claim to be true. So you can see counsel did the math. That's an excerpt from the complaint. Again, this is sort of a branching out of the number of servings types of cases where all somebody had to do to bring the complaint was do some math. And so it's important, obviously, for companies to make sure that they're tracking this internally and getting the numbers right. So 2021 also saw a reemergence of challenges to allegedly deceptive discount prices. So these cases usually involve retailers, clothing retailers, not always. You can see some other examples here. So unsurprisingly, those cases slowed at the start of the pandemic, but they picked up in 2021 and 22 with cases being filed against major brands like Adidas, Hugo Boss, and many others. Basically, the plaintiffs in these cases allege that the retailers are advertising fake, original, or MSRP prices, and then advertising the products at discounts from those prices, which are not true discounts because the original prices or MSRP prices are not real. And according to the plaintiffs, this misleads consumers into buying products thinking they're getting a discount, and then they buy the products that they wouldn't otherwise buy. These cases, you can see on this slide, are mostly focused in California these days. The reason, we'll give an example on the next slide, but the reason is these cases have not fared very well outside California, and I'll explain why I'm talking about this case. So this is a case we handled for PVH, which makes clothing like Van Heusen, Calvin Klein, Tommy Hilfiger, other brands. This case, the plaintiff alleged that he bought some Van Heusen clothing that was advertised at a 60 to 70% discount, and supposedly, according to his complaint, the original prices that the discount was calculated from were fictitious. The court granted the motion to dismiss, first finding that the plaintiff failed to plausibly allege with the level of particularity required. After all, these are fraud cases, so Rule 9b applies. That the plaintiff failed to plausibly allege an investigation was done that was sufficient to support those allegations. So one thing we've seen is with these wave of cases, often they get filed against retailers without a lot of investigation, and obviously, there's some bad apples out there, but you need to do the requisite investigation before you allege fraud, and the plaintiff hadn't done that here. The other problem with the case, and this goes back to the sort of Ninth Circuit split from the rest of the country I was talking about, is the court agreed with our motion to dismiss argument that the plaintiff had not plausibly alleged an ascertainable loss or an injury that you could calculate because of the allegedly fake discounts. The plaintiff didn't allege that the products he bought were damaged or defective or otherwise worth less than he paid. So he paid a certain amount of money, you got a product worth that amount of money, and so the court found you had an alleged injury. The Ninth Circuit has taken a different approach and basically said that failure to get a discount is an injury. And so that's why those cases have tended to be focused, particularly in the last few years in California, as courts elsewhere have rejected that theory. So safe and non-toxic claims have also been popular the last few years. I think part of that is advertisers making more of those claims, but they're definitely getting targeted by the plaintiff's bar, particularly in the cleaning and household goods area. And usually in these complaints, they're not alleging that the product is, it's causing fatal injuries or even very serious injuries. The theory is even if there's any amount of injury or potential for injury to people, pets, kids, the environment, etc., you can't say that something is safe or not toxic. Some of these cases have been dismissed, some have settled for millions of dollars, so it is an area to watch out for if you're making these types of claims and to make sure there aren't any ingredients in your product that are sort of low-hanging fruit, like we were talking about, to get a challenge. And related to these cases are cases challenging charcoal toothpaste products, which sometimes have safety claims in connection with them. Those have been a pretty hot area for the plaintiff's bar. However, there was a recent decision very recently involving Crest toothpaste that may stem that tide. The court dismissed the complaint that was alleging that Crest toothpaste containing charcoal are falsely advertised as being enamel safe or providing gentle cleaning, when according to the plaintiff, the fact that there's charcoal in the toothpaste precludes those benefits. And the plaintiff also alleged that P&G fails to disclose that charcoal has not been substantiated as a safe and effective dentifrice. So the court dismissed those claims because the plaintiff failed to allege that the amount or the composition of charcoal in this toothpaste was unsafe for use. So basically what the plaintiff did was cite articles and studies about charcoal as a dentifrice in general, but not charcoal toothpaste specifically, and certainly not Crest toothpaste containing charcoal. And so the case was dismissed. The plaintiff is appealing that dismissal to the Second Circuit Court of Appeals, and so this is a case to continue watching, given there have been a lot of challenges in this area. So another type of claim that's often made in advertising and is often challenged is the claim that a product's benefits are clinically proven, or that there's tests or studies proving that a product has a certain benefit. So these cases can be challenging to bring as class actions because consumers can't challenge advertising on the ground that it's unsubstantiated. They have to allege that it's false. So this was a case we handled for Zicam. The plaintiff alleged that Zicam lacks valid support to claim its products are clinically proven to shorten colds. And the court found that that amounted to a lack of substantiation theory, not a falsity theory, and therefore did not state a claim. So the plaintiff didn't just come in and say lack of substantiation. They did try to allege falsity. The way they did that was by citing clinical studies of various non-Zicam zinc products and saying, well, in these studies of other products, zinc was found ineffective. But kind of similar to the charcoal case, the court said you can't rely on studies of other products or zinc generally to allege that Zicam products do not work. You would need studies of Zicam itself. And so the court dismissed the complaint.
All right, so undisclosed ingredients cases. So these are cases alleging that products contain dangerous ingredients or really the contaminants that are not disclosed on the product label. And I think as to whether they are actually dangerous in the quantities that they present themselves in these products is a real question. No one wants these contaminants or substances in their products. But having said that, sometimes it's just unavoidable, and heavy metals is a good example of that. Heavy metals occur in the earth. So if we're eating fruits and vegetables, we're consuming some heavy metals, but that is the landscape that we're looking at in terms of class actions. So on the subject of heavy metals, we saw an explosion in baby food cases alleging the presence of heavy metals a couple of years ago, following the congressional committee report that came out reporting on heavy metals in baby foods. There were over 100 cases filed against baby food manufacturers, and we have also seen these types of cases filed in other industries. So spice manufacturers is one that comes to mind. And those cases typically rely on a November 2021 report that was published by Consumer Reports titled "Your Herbs and Spices Might Contain Arsenic, Cadmium, and Lead." Earlier this year, we saw a wave of cases alleging the presence of benzene in sunscreen and other aerosol products. And then more recently, we've been seeing PFAS cases. So a rise in cases alleging the presence of PFAS in products, mainly cosmetics and fast food packaging, and alleging that those are harmful to people and to the environment. Most of these cases are still in the very early stages, so we don't really have a good indication yet from courts as to where they're going to go. But we have seen a couple of recent decisions in the baby food space, and they basically indicate that it's probably going to be a mixed bag. So the Plum baby food litigation case, the court largely denied the defendant's motion to dismiss. It was a very short opinion. There's not a whole lot we can glean from it. But then in the Sprout Foods case, the defendant fared better. So there the court actually granted the motion to dismiss and found that plaintiffs failed to allege that the products contained enough heavy metals that would be sufficient to establish an injury. All right, so moving on to claims like kills 99% of germs. So unsurprisingly, a number of those cases have been filed since 2020 when a little thing called COVID entered all of our lives. Of course, they're being filed against manufacturers of sanitizing products, so wipes, hand sanitizers, etc. Most of these cases have not fared well at the motion to dismiss stage, since courts generally find that a reasonable consumer would not be misled, and here's a good example of one of those. So this was a case filed against CVS related to its private label hand sanitizer. So the product had a claim on the front label that said it kills 99.99% of germs, and there was an asterisk linking to a back label disclaimer that said it was effective at eliminating 99.99% of many common harmful germs and bacteria in as little as 15 seconds. So the plaintiff said that front label claim is misleading because the product doesn't actually kill 99.99% of all germs that are out there. The court did not agree. The court said a reasonable consumer is not going to look at this label and understand it to mean that this product kills 99.99% of all conceivable germs that are out there. The court actually said, it defies logic to think that a reasonable consumer is going to expect this product to protect against illnesses that are spread by things like drinking contaminated water or STDs, for example. And what's interesting about this is I think plaintiffs thought that COVID was going to work in their favor in this case, but the court actually went the other direction and basically said, at this point we've been through almost 2 years of a global pandemic, and reasonable consumers know what hand sanitizer does. It's there to sanitize your hands. And given COVID, the court was also pretty skeptical of the plaintiff's allegation that if he had known that the product didn't do what he thought it did, he would not have purchased the product in March of 2020, just given there were very few consumers standing at store shelves in March 2020 thinking, if this doesn't protect me against STDs, I'm not going to buy this hand sanitizer. So then the court also did point to the disclaimer and said that that clearly discloses that the product doesn't kill all germs, only 99.9% of many common harmful germs. All right, so cases involving no artificial flavors and free of claims have been a pretty consistent trend for several years now. Some of these cases have made it past class cert and some have resulted in pretty large settlements. So this is definitely an area to be looking out for. And as in the flavoring cases that Jeff was talking about, again, plaintiffs tend to target the same types of ingredients over and over again. So we've listed some of those here. Citric acid and malic acid at the top of that list are probably the most popular, and they've also been the most successful for plaintiffs, especially in cases alleging no artificial flavors claims are false. So for companies that do have no artificial flavors claims, if your product contains one of these ingredients, you probably want to think about these types of cases. And these are hard because business people will tell you that these ingredients are not functioning as a flavor in the product. And that may very well be true, but the issue that comes up is courts generally have not wanted to resolve that issue at the pleading stage. So at that point, you're looking at discovery, you're looking at possibly even class cert. So here's an example of one of those cases. General Mills was sued over its no artificial flavors claim in a product that contained malic acid. And the allegation, of course, that claim was false and misleading because malic acid acted allegedly as an artificial flavor. So General Mills did file a motion to dismiss in this case, and they argued that the malic acid was being used as a pH control agent, not as a flavor. But as I said, the court said it wasn't going to resolve that issue at the pleading stage. So then the parties got into discovery and they eventually settled. So the terms of the settlement require General Mills to remove the claim. There is no monetary compensation for the class, but General Mills is going to be paying $600,000 in attorney's fees, assuming that the settlement gets approved. It has not yet been approved, and a previous settlement was actually rejected. But this is just an example of where these types of cases can end up. All right, having said that, it's not all bad news for defendants out there. So Kellogg did much better in this no artificial flavors case, again involving malic acid. Again, the parties got through discovery. They actually got to class cert, and class cert was denied. So of course, for a class to be certified, the named plaintiff has to have claims that are typical of the class. So if there's something unique or unusual about the named plaintiff, that can be a basis for denying class cert. So here, plaintiff alleged that Kellogg was falsely advertising Pringles as containing no artificial ingredients, but the plaintiff happened to be a professional pastry chef who went to an elite culinary school and was trained in molecular gastronomy. At his deposition, he said, "Price is of no concern to me when I'm shopping, and I am really, really averse to packaged foods, so I make my own rigatoni at home." So in denying class cert, the court said, you are not the typical Pringles purchaser, and in particular, you are not typical in your zealous avoidance of artificial ingredients. So icing on the cake here is the plaintiff's wife happened to be an attorney at one of the law firms that was seeking to represent the class. At his deposition, the plaintiff said he was first told about these artificial ingredients by his wife, and she probably found out through work or something. So the court basically said, hey plaintiff, you're going to be uniquely susceptible to questions as to whether this suit is being brought for your benefit or for that of your wife's firm. We're not getting into discovery this morning, but this is a good example of the type of factual record that defendants want to be developing in discovery. So natural claims, they are still being filed all the time, and we have also seen an increase in plant-based claims. So in these cases, plaintiffs are typically alleging that the plant-based or natural claim communicates that the product contains only plant-based or only natural ingredients, even though the advertising itself doesn't necessarily say all natural or 100% natural. So here's an example of one of those cases, and here the defendant filed a motion to dismiss, basically saying a reasonable consumer is not going to think that this product contains only natural or only plant-based ingredients. The court denied the motion in this case and said it couldn't resolve that question at the pleading stage. All right, so there have been several class actions over healthy claims in recent years. We use the word healthy as shorthand, but these are really cases where plaintiffs allege that defendants are making some sort of claim that their products are good for you, whether that's with the word healthy or wholesome or nutritious. But then they allege that the products have high sugar content and those increase the risk of chronic disease with regular consumption. So Baldo mentioned both of these cases earlier. They both involve cereal and some other food products, and they resulted in pretty considerable settlements. So we're continuing to see these types of cases being filed, and we do expect more to come in this area. All right, so just to wrap this up with some discussion of ESG and social issues. So social issues have become more important to both consumers and marketers, so they have also drawn the attention of class action plaintiffs. Animal welfare claims are definitely one component of that. And companies can sometimes substantiate these claims, but it's just important to make sure that the claims are being specific about the ways in which the business is supporting animal welfare. Puffery is not always a good defense to these cases, and that's shown in this pair of cases that was filed against Pete and Jerry's. So in Lugones, the court did find that some of the statements like, we love our hens, you'll love our eggs, better lives for hens means better eggs for you, were paradigmatic examples of puffery. But then it found that others, like most hens don't have it as good as Nellie's, our hens can peck, perch, and play on plenty of grass, that those were factual claims that a reasonable consumer could rely on and therefore needed to be substantiated. Similarly, in Mogul, the court rejected the argument that claims about hens' free range and outdoor forage lifestyles were puffery. But some claims truly are puffery, as we see in this case that was filed against Allbirds. So here plaintiff alleged that Allbirds' advertising related to happy sheep living the good life and other claims about humane treatment of sheep that provide the wool for Allbirds' shoes were false and misleading. So the court granted the motion to dismiss and found depictions of happy sheep in pastoral settings and the statement that our sheep live the good life were classic puffery. The plaintiff here also did plead that there had been findings of sheep cruelty in a number of farms, but the court said the plaintiff did not do enough to tie those farms to Allbirds. Basically, he didn't actually allege that Allbirds was using any of those farms to source its wool. The same sorts of principles apply to environmental and sustainability claims, which are, of course, also very important to marketers right now. Here, advertisers should make sure that they are complying with the FTC Green Guides, and there are a couple of reasons for that. First, obviously, it's always a good idea to make sure you're in compliance with regs, but from a class action perspective, plaintiffs often allege that in these types of cases, that defendant is failing to comply with the Green Guides as a basis for why the advertising is false. And then on the flip side of that, if you are sued under California law, compliance with the Green Guides is a defense to these types of claims. So again, advertisers should be specific about the environmental benefits that are being advertised. And one of the main dangers with these types of claims is that if you're not specific enough, a plaintiff may argue that it conveys something broader, that the product in its entire life cycle is good for the environment or actually has a positive impact on the environment, for example. So closely related to environmental claims, of course, are recyclable claims. So NPR and PBS came out with an investigation back in 2020 related to the recyclability of plastic. And we wrote an article back in December of 2020 following that investigation, predicting that class actions around this topic would be coming. So a pat on the back for ourselves, we were right. Thank you. So there have since been a number of class actions alleging recyclability claims are false and misleading. So this includes a series of class actions brought against beverage bottle manufacturers, alleging that the 100% recyclable claims on these plastic drink bottles are deceptive because the bottles are made of PET and domestic facilities allegedly only have the capacity to process some portion of the total PET that is sent out for recycling, and then similar issues relating to labels and caps. So defendants have moved to dismiss in these cases. They've argued that reasonable consumers will not interpret a claim that something is recyclable to mean that it will in fact be recycled. Defendants say, our bottles are absolutely made out of recyclable materials that can be recycled. And whether a given bottle is ultimately recycled is out of the defendant's control. It depends on what's happening at the recycling facility, their capacity, the quantity of other materials that they're collecting. And they say reasonable consumers will understand that and therefore will not understand 100% recyclable here to be a guarantee that every bottle will actually be recycled. So that motion is pending and is going to be pretty informative as to where these recycling cases are going. We may also be getting an update to the Green Guides this year, so a lot more to come here. All right, so those are our class action trends. Here we just have a quick summary of courts where class actions are frequently being filed. It's just good to know for if you're looking at individual state laws, state consumer protection laws, the ones that are most relevant. And California, of course, is always high on that list. But New York, Illinois, and New Jersey are also pretty prevalent.
So the last portion of our presentation has to do with settlements. Obviously, class action cases in the advertising space are resolved in a number of different ways. Some are resolved pre-suit, many are resolved on a motion to dismiss. When courts grant the motions to dismiss, they get resolved in the class cert stage when courts grant the or deny the class certification. Of course, if there's a denial of class cert, the case is essentially over because you're dealing with one plaintiff, and they get resolved in summary judgment and sometimes at trial, but fair number gets settled. I don't want to give the misimpression that settlements, especially class settlements, are the norm, but I think for the purposes of today, we're going to focus on settlements, in particular class settlements, even though many cases are resolved without settlement. So settlements can happen at any time. Oftentimes you get a demand letter, your client gets a demand letter, and they can be resolved pre-litigation. In California, if you want damages, you have to give at least 30 days notice under some of the laws. And so that's an opportunity to discuss with plaintiff's counsel the strengths of your case. It's also a good time to share your substantiation if, in fact, you want to share that. And there's obviously risks and benefits. There's some risks with that. There's also some benefits with that. The risk is that if you're dealing with plaintiff's counsel that has no intention of really settling, all you're doing is educating them. But obviously, if you're dealing with counsel that is open and to hearing about substantiation, and they don't want to engage in long, protracted litigation, which they're going to lose, then they will, sometimes drop their demand and you show them that. But in any event, settlement really, it's a matter of leverage, obviously, in any case, and it also depends on where you are in the case and your jurisdiction. So, if we talk about the components of settlement or the considerations, the first thing is, are settlements going to be on an individual basis or on a class-wide basis? There are big trade-offs for each. If you look at an individual settlement, it's definitely much less expensive to settle these type of cases. They are not public, and oftentimes the injunctive relief is not as onerous as it is when you settle class. But the trade-off to that is that the protection is limited, right? You're just getting protected by that individual plaintiff. There's a release from that one plaintiff, and so it exposes you to a client to copycat cases. So that's something that is a downside to an individual settlement, notwithstanding the many upsides. Class-wide settlements do provide protection. They provide protection because unless someone has opted out, all members of the class are bound by the settlement, including by the release. On the other side, if you're looking at it from an advertising point of view, the downside to a class-wide settlement is that it's public, and it's going to be more expensive than an individual settlement. You're going to compensate the entire class, and also the attorney's fees tend to be significantly higher in a class settlement. So that's something that is really a matter to discuss with your client. It's there's lots of considerations that go into settlement, including a class settlement. Generally, these type of settlements, there is no admission of liability, and it's really just done on business terms that make sense for both parties. So some of the considerations we talked about, the individual versus class, but then some of the other considerations are the type of injunctive relief, or the type of relief. There's injunctive relief, obviously, that could be anything from label changes to clarifiers to other sorts of relief. Then there's the monetary component, which we talked about. That includes payment to the class, payment to the lawyers, administrative fees, notice fees, and whatnot. And there's also other non-monetary type of compensation that you can provide to a class, such as merchandise certificates. And oftentimes our view is that plaintiffs in class will continue to buy the product, so it's not that they're dissatisfied with the product itself. And so providing a merchandise certificate is beneficial to both the consumer who's going to buy this product again, as well as to the defendant in the case. Then we'll talk briefly about some advanced considerations for class settlements. This is mostly in the settlement agreement. You want to account for the timing of the injunctive relief. If there's going to be injunctive relief, like label changes, obviously there has to be a sell-off period. In the area of the time of COVID, we also want to make sure that there's availability of the product, of new labels, because that has been a concern. We want to define the class. Sometimes it differs in the class that's identified in the complaint for many reasons, and we'll talk about why you don't want to go too broad, but you also don't want to go too narrow. Then there's the allocation of the settlement funds, and then there's the whole issue of reverter versus cypre. For example, the Ninth Circuit does not like reverters. You want to make sure that if there's any amount left over, it either gets distributed to the class, or there's some sort of cypre generally connected to the type of claim you bring. And then there's obviously the notice and accounting for public statements. Like I mentioned, most of these settlements, there's no admission of liability, and so you want to make sure that both sides are comfortable with the type of public statements that are going to be made. And of course, there's opt-out, so you have to be careful and anticipate that. And that's a separate topic, but that's something that you're obviously not bound by the settlement agreement. Courts are very sophisticated in terms of providing guidance for class action settlements. We see here some of the guidance provided by the Northern District of California. A lot of California state cases have similar guidance. And it's really useful when you're entering into a settlement agreement to look at the guidance, right? Because it really makes a difference when you go to court for the preliminary hearing or even for the final hearing, and you have, at least if you're on the same page with opposing counsel, you could walk through the checklist with the guidance, and you ensure or you maximize the potential for an approval. Again, here are just some of the guidelines by the Northern District of California. Again, the courts really scrutinize these factors, especially at the preliminary approval stage. And it's really helpful to do that at the preliminary approval stage before the notices go out, before you spend a lot of time with the class administrators. And again, what do courts look at? They want to look at the class. Is the class too broad? Is it too narrow? The release, is it too broad and too narrow? And then, like I mentioned, the reverters, especially in the Ninth Circuit, you want to be careful to avoid those reverters. I won't get into it today because we're running out of time, but here's an example of a class settlement that was not approved by the court. The settlement was 15 cents per unit. If all the purchasers would have submitted a claim, that would have been $67 million. Of course, and $6.85 million in attorney's fees. Of course, that didn't happen. The rate was much lower, and the redemption rate was actually 0.5%, which made the counsel's fees really disproportionate to the amount the class was getting, so the court did not approve it. So that's obviously something to think about. With that, I think we're running out of time, so I'll wrap it up. We have a blog. We talk about these topics all the time, and we actually issued a year in review that just published a little while ago. It talks about all the trends, a lot of what we talked about today, but goes into a little bit more depth. So thank you all for attending. If there are any questions, we're happy to address them at this time. Yes?
So obviously the general counsels at these companies are working around the clock to box the risk, right, when they launch new products. But in your opinion, do you think these companies look at product launches and the suits that are brought as a cost of doing business?
So, that's a great question. I think what we're seeing is that, yes, every time there's a product launch, they are looking for substantiation. And they're making sure that the products are substantiated, but they understand the trends, right? That it may be a cost of doing business, even though you feel that you're right, even though you do have a substantiation, that doesn't immunize you from a class action suit. So there is a component of that. They understand that. Look, if in fact we bring this launch this product, especially in a hot area, like Jen talked about the naturals, then there is a likelihood that you're going to get sued, and then there's attorney's fees. But at the end of the day, I think they're trying to do what's responsible. I think there is substantiation, but if you're talking about an area where it's factual, yeah, it's a cost of doing business, because most likely the case might get past the motion to dismiss it. You might win at the end of the day, but there is a cost to that, and that is a factor that this company's taking into account. Thank you.